I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this lesson on New England state courts. This lesson is the second in our series on state courts, so if you haven't already, please view the introductory class for your respective state before moving on to this lesson. All classes can be found in our FOI guide at NEFAC.org, as well as on our YouTube channel, 5 Freedoms. In addition to state courts, we also offer lessons on state public record and open meeting laws, as well as the Federal Freedom of Information Act. Each class builds off one another, and they all collectively provide a curriculum you won't find anywhere else. Before we begin today's lesson, a special thanks to everyone who is helping us make these classes happen. SBJ New England, the Rhode Island Foundation, and the New England Society of News Editors. We appreciate everyone's support. Now, to introduce you to today's instructor, Emily Sweeney.
Hey everybody, I'm Emily Sweeney from the Boston Globe, and I want to thank you all for joining us for this webinar, which is brought to you by the New England First Amendment Coalition. And now this session is going to focus on the courts in New Hampshire and how to access court documents and hearings. And with us is NEFAC's president, Greg Sullivan. Greg is the general counsel for the Union Leader Corporation and also teaches at Suffolk University Law School and the Nacke Loeb School of Communications. And he's going to explain in greater detail how the courts work in New Hampshire and how to access court documents and hearings. Greg, thank you so much for being here.
Thank you for having me. Hi, everybody. Good morning or good afternoon or good evening, depending on when you are either watching it now or in the future. It'll be available on NEFAC's website. So I start this webinar with the First Amendment, because it is the First Amendment, among other things, as we'll see, that guarantees our ability to access court proceedings and court records. The words right to know don't appear in the First Amendment, but our freedom of speech and press and our ability to petition the government for a redress of grievances would be greatly weakened if we did not have a corresponding right to know what the government is up to. I generally start my webinars with this slide, which is the United States Constitution. I'm hopeful you can all read the words that to me count, and there's 4 words that I see as key to this field of study. We the people, pretty easy to see. And I think the founding persons put those in big letters for a reason. And the last word, the 4th word that you may be able to read, is near the bottom. It says done. We the people done. And that says it all to me. We the people own the courthouse, the White House, the police station. We are the government. So Emily wants me to talk about access to the courts of New Hampshire and their records. And this slide tells me we have a limited period of time, so I have to speak with some degree of rapidity. And I will admit that we're going to touch the elemental concepts of the right to access court proceedings and court records, but it really requires more study than we'll be able to do in the next 28 minutes. So, like the federal government, the state of New Hampshire has its own constitution and Bill of Rights, which predates the federal constitution. These 2 articles really need to be read together, that the people of this state have the exclusive right of governing themselves, and all power residing originally in and being derived from the people. All the magistrates and officers of government are their substitutes and agents, and at all times accountable to them. That's pretty self-explanatory. However, in 1976, the legislature felt that it needed to be emphasized more strongly. So in 1976, they added a paragraph to Part 1, Article 8, that says, government therefore shall be open, accessible, accountable, and responsive. To that end, the public's right of access to governmental proceedings and records shall not be restricted. All right, I skipped a word. Shall not be unreasonably restricted. And that is the word that is bandied about in courtrooms every day when people are trying to access governmental records, which the government is denying. Part 1, Article 22, of course, guarantees free speech and free press in stronger terms than even the First Amendment. They are essential to the security of freedom in a state. They ought therefore to be inviolably preserved. However, as those of you who have interacted with the government, and not always to your satisfaction, realize that there are, on the left train, represents to me our rights to free speech, free press, and access to governmental records and proceeding. However, on the right, that train represents other governmental and societal interests that will crash and clash head on with our right to know, primarily privacy. However, in 1992, the New Hampshire Supreme Court ruled that closing a courtroom or sealing a document requires proof by the person or the agency that is trying to stop the disclosure of the records or the closing of the courtroom. They must prove a sufficiently compelling reason that justifies preventing public access. And the court has to determine there's no reasonable alternative to non-disclosure and no less restrictive means being available to accomplish the purposes advanced for the closing or non-disclosure. That case dealt with divorce records of a public figure, a former member of the Supreme Court of New Hampshire, in fact, who had gotten divorced and didn't want, and his ex-wife didn't want their divorce records and all that was contained therein to be disclosed to the public. However, we have in New Hampshire and elsewhere a balancing test. The rights of access to these records are weighed and balanced against privacy interests that must be articulated with specificity. And in that case, the court ruled that the public's right to know how the courts are operating outweighed the privacy interests of the individuals involved in that case. The key case in New Hampshire on access to proceedings and records is Associated Press versus State. And in that case, the court said such access is critical to ensure that court proceedings are conducted fairly and impartially, and that the judicial process is open and accountable. The public has a right to know how these agents of ours are proceeding and performing in their critical roles. Again, AP State, closed proceedings, although not absolutely precluded, must be rare and only for cause shown that outweighs the value of openness. Where the state attempts to deny the right of access in order to inhibit the disclosure of sensitive information, it must be shown that this denial is necessary because of a compelling governmental interest and is narrowly tailored to serve that interest. And I'll give some examples momentarily. Again, AP State, there must be a showing that the denial serves an important governmental interest and that there is no less restrictive way to serve that governmental interest. And very important for all of us to remember, there's a presumption that court proceedings and court records are public. Burden of proof is always going to rest on a party, always going to rest on the government or a party seeking closure of court records to demonstrate again with specificity that there is some overriding consideration or special circumstance that is a sufficiently compelling interest which outweighs the public's right of access to those records. We think back to those two trains crashing. I'm compelled to say there are cases. Let's take an example, a minor victim of a sexual assault. When that young person is going to testify, it may very well be appropriate for the court to close the proceedings to the public and the press. It used to be in Massachusetts that was per se an exemption from closure. And a case called the Boston Globe versus the Superior Court got the Supreme Court of the United States that said, no, it all has to be decided on a case-by-case basis. It can't be a per se exemption. In AP versus State, somewhat tricky, the Supreme Court of New Hampshire imposed what's called the experience and logic test when analyzing requests to close a courtroom or seal a document. It's in a civil case. Has the type of proceeding or document historically been open? Does access advance an important interest? For example, promoting confidence in the system or encourage better decision making. We like to think that the public being in the courtroom may make sure that whether it's the prosecutor, the defense counsel, the judge, are handling things in an appropriate and fair manner. There are rules that says, and this is an important one in the Superior Court, and it holds true for all courts, Supreme, Superior, District, or Circuit as they call it now, except as otherwise provided, all pleadings, attachment to pleadings, exhibits submitted at hearings or trials and other docket entries, documents, shall be available for public inspection. This rule shall not apply to confidential or privileged documents submitted to the court for in-camera review. And what in-camera review means is the petitioner is saying to the court, Your Honor, we believe these records should be disclosed so that the public knows how the government agents in this particular case were performing and how their supervisors were performing. And the party seeking closure, many times a city, town, police department says, no, we can't disclose this information because it will interfere with ongoing law enforcement proceedings, for example. So what happens is the documents have to be submitted to the judge for the judge to review in his or her chambers. The cases say that the parties should be involved in that process in the in-camera review, but my experience has been Superior Court judges often just do it on their own. And I will say generally do a great job. So what is this confidential information? Some information, classified materials, for example, by the federal government, there are statutes that require this information not to be disclosed to the public. And then we get into what I will call more of a gray area. Information which, if publicly disclosed, would substantially impair the privacy interests of an individual. That's where the balancing test comes in. Same with the business, financial, or commercial interest of an individual or entity, or the right to a fair adjudication of the case, or information which a party can establish specific and substantial interest in maintaining confidentiality that outweighs the strong presumption in favor of public access to court records. 1997, in the case of Union Leader versus New Hampshire Housing Finance Authority, the court ruled that a private company who had submitted information to the state in order to build a public housing facility. The company had said, well, disclosing this information will give our competitors, when we do other projects elsewhere, an unfair advantage when they see our financial, confidential, commercial information. And the court ruled no. If the information will shed light on the performance of the governmental agencies involved, then the privacy right of the company will have to take a backseat. So in New Hampshire, we have RSA 91A, which governs most governmental action, but not the courts and not the governor, I must say. So like the 91A cases, when we're dealing with court records, which, by the way, the courts are not covered 91A, so anyone petitioning to get documents has to rely on Part 1, Article 8 of the New Hampshire Constitution, which we looked at a few moments ago, saying that these governmental officials are our agents and servants and must at all times be open, accessible, and accountable to us, the public. And when I say the public, if you remember the press, I'm going to say, and it's a topic I'm going to take up in a few minutes, to me, with respect to most dealings, there is no distinction between the public and the press. They have the same rights. So like the 91A cases, the court cases deal with exemptions. That's what we find all the time. And some of these grand jury proceedings closed. We never get them. Juvenile proceedings, adoption proceedings, Department of Children, Youth and Family hearings, all closed. Termination of parental rights. Testimony of a minor victim of a sex offense. Now in New Hampshire, that's per se exempt. Massachusetts, not so, but it is decided on a case-by-case basis. And a civil commitment hearing, where some family member or police department are seeking to have someone committed to incarceration because of their behavior, privacy interest will make that hearing exempt. A lot of the cases and the work of trying to seek court records have to do with criminal cases. And by statute, affidavits that are filled out by police officers or other governmental officials in order to support the issuance of a search warrant and also an arrest warrant shall contain facts, information, and circumstances upon which the person relies to establish probable cause for the issuance of the warrant. And such affidavit may be supplemented by oral statements under oath for the establishment of probable cause. However, once the warrant is issued and the search or the arrest has taken place, by statute, the warrant and the affidavit and the notes are filed with the court, and they shall be a public document when the warrant is returned, unless otherwise ordered by a court of record. And often the police departments who have effectuated these searches will say, well, Your Honor, please keep that affidavit sealed because, and they have various reasons. It's an ongoing investigation. We think there may be other arrests, or if we disclose the identity of witnesses, they'll be hesitant to continue with their assistance of the government in the prosecution. And that's a fight that happens in court with frequency. And again, it's the government that must prove that sealing serves a substantial and compelling interest. Again, juvenile case and court records are exempt from such records shall be withheld from public inspection. And in New Hampshire, they mean it. It's a crime to disclose court records with respect to juveniles, and any person who knowingly violates this provision shall be guilty of a misdemeanor. Unlawful for any newspaper to publish or any radio or television station to broadcast or make public the name or address or any other particular information serving to identify any juvenile arrested without the express permission of the court. Any proceedings, again, cannot be disclosed without permission of the court. It does go on to say, this statute, that if the delinquent conduct would constitute a felony if it were the act of an adult, then that information can be published. There's never been a case, to my knowledge, in New Hampshire when any newspaper, radio, or television station has been prosecuted for violating this statute. There was a case in Florida, Florida Star versus BJF, many years ago, where a newspaper published the name of a minor sex victim, which was a violation of the statute in Florida. Case went to the Supreme Court. Supreme Court said if in this case it was a newspaper, if the newspaper obtained the information lawfully, they could not be punished for publishing truthful information. Never been tested in New Hampshire. And the statute is there. Publisher of any newspaper or the manager, owner, or person in control of a radio or TV station who violates any provision of 169B shall be guilty of a misdemeanor. So, who has the right to access courtrooms with a camera? And I will say, this was a long, exhausting fight for the media to be able to bring cameras in the courtrooms in New Hampshire. I had a lunch meeting to discuss this issue one time with the Chief Justice of the Superior Court in New Hampshire. And when I brought up the subject over lunch, he flatly said to me, cameras will be in the courtrooms in New Hampshire over my dead body. However, the media kept up the fight, and cameras are now certainly allowed in the courtrooms of New Hampshire. And I believe that Chief Justice, although retired, is still alive. But what the rule is now is, and this is a Superior Court rule, except as otherwise provided, or any other provision of law, any person, whether or not a member of the press, and nowadays distinguishing who's a member of the press and who isn't, is not the way it was 30 and 40 years ago. Pretty much everybody with a smartphone, a laptop, or a computer can be a member of the press, obviously. So this rule says anybody is permitted to photograph, record, and broadcast all court proceedings that are open to the public, provided that such person provides advance notice to the presiding justice in accordance with Section C of this rule that he or she intends to do so. There have been cases when arrests have been made in the middle of the night, arraignment's going to happen at 9 a.m., and the media people with their cameras haven't had the ability or opportunity to notify the presiding justice in advance, and that's actually been well understood by the judiciary. No problem. But again, the rule says nobody's going to photograph without advance notice. In addition to giving any parties in interest an opportunity to object, and it's often a criminal defendant, the purpose of the notice requirement is to allow the presiding justice to ensure that the photographing, recording, or broadcasting will not be disruptive to the proceedings and will not be conducted in such a manner or using such equipment as to violate the provisions of this rule. What happens nowadays when there's a high-profile case, a murder trial, for example, and there are 10 media organizations that want to bring their cameras in the courtroom, the court will rule that only one camera will be in the courtroom, all others will be in an anteroom, and they'll all have the same feed simultaneously as the camera in the courtroom. So they all can fairly and at the same time report what's going on to their audience. As far as the rest of us go, in terms of access to court records electronically, to access docket information online for the Circuit Court, the Superior Court, or the Supreme Court, you go to this website. I'll slow down a little bit if anybody wants to jot it down. But crazy thing is there are it's not simple and it's confusing. Separate portals for attorneys, self-represented parties, and non-attorneys. Also, separate portals for electronic filing and case access to review a docket of a case. After registering, you can use the portals to file into a case and/or review a docket. But to have access to the documents online, in other words, you get the docket says a motion to seal was filed yesterday. You cannot click on that entry and see the motion to seal unless you are a party to the case. Now, you certainly are free to go to any courthouse and access any records. A lot of times, unfortunately, not so much these days, but historically, when reporters have gone to the courthouse and asked for a file on a high-profile case, the clerk will say, well, the judge has that file in his chambers. And so, sorry, we can't give it to you. And that file might stay in the judge's chambers for weeks at a time. So Emily told me she has the ability to field questions and put it in a chat box. I think that's right. And by the way, there will be a slide giving information about contacting NEFAC or contacting me. I'm always glad to field questions and answer them as best I can on First Amendment and right to know issues. These websites, nefac.org, courts.nh.gov, RCFP is a great website, the Reporters Committee for Freedom of the Press, because their website has information on these issues with respect to all 50 states. Just pick the state you want, click on it, and you'll get very up-to-date information on our right to know what the government is up to. Additionally, the lobeschool.org, Emily mentioned I teach there, and our website has plenty of resources for all of us.
Greg, like you were saying, all these websites are great, especially NEFAC. Be sure to check out our previous episodes of these webinars, which have been, really helpful. I've learned a ton, that's for sure.
The next slide, excuse me, was going to say, thank you for joining us. And it was going to have my email information, which I'll have to give you orally, which is g.sullivan@MSLPC, Malloy and Sullivan Lawyers Professional Corporation, MSLPC.net. Happy to hear from anyone on these issues at any time.
Excellent. Well, hey, thank you, Greg, so much for giving this great presentation. Thanks to everybody who tuned in and watched live. And be sure to check out our next classes. We're going to be having more of these. So thank you, everybody.
Thank you, Emily. Talk to you soon.